So here we are, Tuesday, 3:30, May the 4th. And as usual, I'm here to do my live. It looks like I hopefully have the comments on again today. You remember a couple of weeks ago I had that messed up. I guess because last week we had some gun questions. This week I've got a bunch of questions, on homicide or murder, self-defense, and so I'll kind of go through them and see what all we have. The first question I had was, is it legal to kill for self-defense? I don't like the way that question is worded. When you say, is it legal to kill for self-defense, it makes it sound like, there's some malice intended, just the way it's worded, and maybe that's just me and the way I'm reading it. But generally speaking, yes. Self-defense is a defense to the use of force, which would lead to death. So in the proper circumstances, if you're in fear for your life and cannot and feel like there is no other option, you may use lethal force as self-defense, and therefore you could kill in self-defense. Although again, I don't like the way that question is phrased. But if you find your life is in danger and you need to use lethal force to protect yourself, you will be justified. Is the stand my ground law a defense? So the way that question is asked, generally speaking, it is. We don't really call it stand my ground in Texas. That became popular with several cases that were televised, sort of like the Castle Doctrine, same thing. If you are in your house, and I think Bill had asked me this question before, if you're in your own house and an intruder is coming into your property to do whatever, you may use lethal force to stop that intruder. You do not have to retreat. So yes, that is a defense as well. You may remember several years ago, there was a case in Pasadena where they were breaking into a neighbor's house, and a man went and defended his neighbor's house and used lethal force, and a grand jury did not indict that man. He was not charged. Can you shoot someone who's trying to break into your vehicle? No, that would be excessive to kill someone for trying to break into your vehicle. The law doesn't recognize the defense of property, such as the defense of vehicle, as a life-threatening situation. So you cannot shoot someone simply for trying to commit the misdemeanor offense of breaking into your vehicle. How long would you be in jail for murder? So, that's a general question that people ask a lot with every offense, and there's no simple answer. It depends on who the victim is, the circumstances of the crime. There are just so many variables that go into it. I know of cases where people have done as little or have received sentences as little as 12 years for murder. But in that specific case that I'm speaking of, it was a man shot and killed the dope dealer that was taking advantage of his wife. And it was, just a strange set of circumstances you don't find every day. And so there is no general answer for how long would you be in jail for murder, because every case and every fact situation is different. It also depends on the decedent. The example I gave a while ago of the guy murdering his wife's drug dealer, that's a different situation. the old lady in the parking lot of Randall's who gets shot for her purse uh, and has no criminal background, that's an entirely different situation. So, as in every case, all of the facts will be taken into consideration when trying to figure out a punishment. And then, of course, it depends on whether or not we're talking about a plea bargain agreement or what the jury, or if the jury is assessing punishment. Either way, though, all of the facts will be taken into account before assessing punishment. So here's a pretty deep question, and it is, what are the 4 types of homicide? And in Texas, we have 4 types. We have murder, and I guess I'll list the 4, and then we can go through each one. We have murder, we have capital murder, then we have manslaughter, and then we have criminally negligent homicide. Probably the most common of these that is charged is murder, and that's, intentionally or knowingly causing the death of an individual. It gets also more complicated. It can be that you intended to cause serious bodily injury and committed an act clearly dangerous to human life that causes the death of an individual, or commits or attempts to commit a felony other than manslaughter, and in the course of and furtherance of the commission or attempt or immediate flight thereof, commits an act clearly dangerous to human life that causes the death. We refer to that as felony murder. In other words, while you're in the bank, robbing the bank, a teller gets shot. And we call that felony murder, and that would mean that everyone involved in the robbery could be charged with that person's murder for participating in the original felony. But again, this murder is probably what is most often charged. That's someone shot someone and someone died, someone stabbed someone died. This is the most common of the 4 charged in Texas, I would venture to say. The most publicized is going to be capital murder. And, the reason that that's going to be the most is because, for one, it can carry the death penalty. But for 2, it can be charged in so many ways. The number 1 way is killing a police officer or a fireman that's in the discharge of their duties as a public servant. The second way is committing murder in the course of committing or attempting to commit kidnapping, burglary, robbery, aggravated sexual assault, arson, obstruction or retaliation, or terroristic threat. Another way is killing 2 people in the same criminal episode. I have actually tried that case as a capital. My client was accused of shooting a man inside of a bar, and then when he was trying to get out of the bar, another Good Samaritan patron tried to stop him, and he shot that man in a struggle and killed that man as well. And so he was charged with capital murder for killing 2 people in the same episode. And we went to trial. He was found guilty, and he got capital life, which means life without the possibility of parole. There are other ways. One is if you commit murder while escaping or attempting to escape from a penal institution, meaning a jail or a prison. Killing someone employed in the prison. These ways aren't too common. Anyway, capital murder, I think, is the most publicized simply because we see that on TV more than we see a regular murder. Murders are charged quite often, unfortunately, but they don't make the paper or the news, whereas capital murder always does, because the circumstances surrounding the murder, usually, like if it's an officer, it's definitely going to be on the news. If it's killing 2 people, it's definitely going to be on the news. And so you might see that more in the news, but in actuality, I'm just telling you, it's not charged as often. Then we have manslaughter. A person commits an offense if he recklessly causes the death of an individual. So that's pretty clear. And then criminally negligent homicide is if you cause the death of an individual by criminal negligence. That one, honestly, I don't see charged that much. It's very rare. Manslaughter is often what we will seek in a murder trial. We will seek a lesser included offense to the jury of manslaughter, depending, of course, upon the circumstances that led to the decedent's demise. And so it's hard for me to get fact specific because each case can be a different set of circumstances. But one thing defense attorneys try to do in all trials, if we feel it's appropriate, is seek a lesser for the jury, claiming that the defense's claim is that the conduct didn't rise to the level of the charge, but rather to the lesser. So that's kind of where we are on the 4 ways to charge homicide in Texas. If you have any questions more specific than that, let me know and we can get into it. Is killing someone in a car accident manslaughter? So it can be. Let's leave out the intoxication offenses, which we can talk about another time. Depending upon the circumstances of the accident, yes, you could be charged with manslaughter, but you'd have to give me a fact scenario to tell you. So accidents can be just accidents and doesn't mean that there needs to be criminal responsibility. Racing, it could raise the stakes. In other words, if you are engaged in illegal street racing and a wreck ensues and someone dies, obviously that raises the stake, and that's not an accident, it's just an accident. Unfortunately, people die in automobile accidents every day, but that's not necessarily criminal. You would have to look at the facts that led up to the accident to determine whether or not the district attorney would attempt to seek charges against an individual. Again, I want to stay away from the intoxication aspect because that's a whole nother level. And again, if y'all have questions about that, I can go through that, the intoxication scenario with Thomas on the DWI side. Can you be held responsible just for being present when someone else kills someone? So I almost think I know who asked this question. Generally speaking, the answer is going to be no. But, I would want to know what were the circumstances. If you're at a party and 2 guys get into an argument and there's lots of people there and one of them pulls out a gun and shoots the other, well, no one's responsible except the shooter. If you and someone else went over to someone's apartment, house, whatever, with the intent to rob them, and then you didn't know it, but the person you're with, who you were going to do the robbery with, pulls out a gun and shoots the guy y'all were going to rob, well, since you were there to commit a robbery, you're going to be on the line for the murder as well under the felony murder rule. And so you would be held responsible just for being present when someone else kills someone. But if you have no involvement in whatever the circumstances are that led up to the killing of that person, then no, you wouldn't be charged with a crime just for being present. You would have to have a participation in something to do with the crime before you could be charged. I hope that's clear. Let me see. And then, of course, the catch-all that, again, that people ask with every type of crime is how do you defend homicide charges in Texas? And, I can't answer that without a fact scenario because, again, every case is different. So how do I know how I would defend any case over another case without knowing the facts? Obviously, we always look for something and find a way to defend everyone and find, it's not, remember that when we try cases, it is not guilty or innocent. It is guilty or not guilty. Innocence is not a choice for the jury. The state has the burden of proof to prove the case against my client, and that burden doesn't shift to me ever as the defense attorney. So whether or not the state can meet their burden is the question. It's not a question of actual innocence most of the time when you're in a jury trial. If the state can't make the case, then we win. Actual innocence doesn't come into play. Can the state meet their burden? That's what I'm looking for. And if I can find a way to exploit something so that the state cannot meet their burden, well, then that's my client's benefit. So how do I defend homicide charges in Texas? I think we have about 5 murders in the office right now, and none of them will be defended the same way. They each have unique set of facts, and they each have their own defenses. I have surely over the summer or by the summer, 1 or more of my murders will get reached for trial. And I guess when I try that case, I can talk about it after. But yeah, each case is different, and so we find a different way to defend every case. I guess that's all I got for today. You all have a good week, and we'll see y'all next Tuesday. Thanks.